All right, Abusia, lawyer Samuel Atta, yes, we're breaking a silence. A legal vacation now, just say, I just almost accord now, so still, almost insist to say there are some cases who are high profile cases in here, so almost appear before court where their clients. Now, Abusia and the lawyer Atta, I break silence. A yes, legal vacation, no one just say. I'm no aim to me and call a year court and co defending a client or no or say vacation is vacation. Nti sɛ ne client no ɛbɛkɔ court deɛ ɔno deɛ ɛnya deɛ a obɛsi ɛyɛ court wei deɛ ma mɛka sɛ wɔpɛ sɛ yɛkɔ no yɛtie nkɔmmɔ no mu ankasa nkyerɛ mu ɛne nsɛm a Samuel lawyer Samuel Atta na ankasa ɛde ato dwa yɛtie ne ma sɛ ha ɛda so ayɛ bɛɛ mi da yɛhyɛ bɛsɛ wa sɛ ɛne de bi kɔ no channel so ne de kwan so ɛbɛsɛ wa so subscribe ɛde ama ɛbɛbɔ notification bell so for podcast updates.
So legal vacation Atta ene Godfrey Dame former attorney general omo akoho say eno ho nti no omo refuse say omo bekwa akọ defend omo client na court SMon Atta after say court SMon Atta say ombra na ombe appear before court no ye drop in ha e de emam lawyer Atta aba be breaking silence the silence now aba be breaking also no the court no he's too old in the game. I just say legal vacation we hunti no emma nimbu embre bia so course Ghana has say since no oba game ni no legal vacation and legal vacation. Enya afi na legal vacation na chief justice ebe panel judges bi ase omunkonko the case enti no he is fighting against a legal vacation trials na ekoso no and the chief justice so ye no obekoso na one no enya adwen sa and right now no ono ankasa na no mutu no right now no o say obe withdraw from Eduboahen case na the client no akofa lawyer for fra no any problem cause or fight against a legal vacation. Right now no as lawyer Atta the tactical Atta instead to withdraw from Eduboahen in the case that ebusua ye de honsem ebra mo yanko na yanko ti silencer the tactical Atta attitude a legal vacation semona court semon no and matters arising now answer na be Ghana has a open computer papa and a laptop papa na we use the Abura periodic computers and accessories ho and I'll be laptop papa na we using the location and ya kwan o Kumase Bokrom Estate Eli free number na egu screen as na dey ba kwa there wo me say okra low budget and a high budget ebusua o mema high quality laptop na we use mommy yanko na yanko nkuti ensmeko.
How you do that? Well, what about your client's interest here? You need to serve his interest. Today he was in court. He's been directed to come back on the 17th. If he doesn't come with you or come with another lawyer, he must do his own cross-examination. That is exposing him to great jeopardy.
Yes, that is coming from judges who have gotten their marching orders from the CJ and they should go ahead with the case. It's like the judge telling my client that, oh, if you have a toothache, go and find a carpenter, not a dentist. How can a judge seriously tell this gentleman that look, where we are, the investigator is the one being cross-examined, but do your cross-examination yourself. I found it very weird, I thought he would tell him that, look, go and find another lawyer if this man is not coming. But I am not worried about what the judge is saying at all.
Congratulations.
This is a position you
yes, I held for 7 years. There was, and something was my vice.
The vice, I remember.
And
you guys caused a lot of trouble. I remember, you guys, the two of you yourself. It's caused a lot of trouble. I remember very well covering the trouble you caused. But yes, he is the president of the Young Lawyers Forum of the Ghana Bar Association. Thank you, gentlemen. And I want to go to Atta first. Mr. Atta, thank you very much for joining us. You were not in court today when your client's case was called. Why? Do I have Atta on? Hi, Mr. Atta,
yes.
Can you hear me? Yes, great.
Yeah.
Great to have you.
Can you hear me now?
Loud and clear, yes.
Okay. Yes. I didn't see myself lending my energies and also my thinking and my being to what I see as an aberration. Because we have a tradition of the bar, we have the Courts Act, and we have CI 47 talking about legal vacation. My dear brother, just look at the linguistic evidence in the law. It's called legal vacation. It's not an ambulance trial. It's got nothing to do with anybody's pleasure. So you have the Supreme Court on vacation. The CJ himself is on vacation. Is that not so? But in the wisdom of the CJ, some judges should sit as vacation judges to deal with emergency situations only, which is by way of a motion. And even the motions are done now by virtual technology. You don't need to come to the court in the comfort of your conference room. You put on your tie, everything, and you start the motion, and that's it. So I'll ask this question. Why should the Chief Justice give a warrant to judges who have heard part cases of some special cases and say that those special cases, they should go for trial? So part heard cases should continue, and these are without the reference to the programs of the lawyers, whether the lawyers will go abroad to do some good medication, or the lawyers who go to International Bar Conference, or the lawyers who travel, whatever. So I keep asking this question. What selective justice is the Chief Justice trying to foist on us? All the murder cases, all the manslaughter cases, all the rape cases, and other criminal cases that are part heard, they are not of consequence at all. The Chief Justice doesn't care about that he wants to bring a warrant that those cases should be given expedited hearing. But these two cases, which a lot of people are talking about, how it is so important to somebody somewhere, should be put together, and then the judge should continue. So I believe that I've come far. I'm not a little boy in the game for me to use one case to cancel the traditions, the practices, and the statutory provisions of Ghana.
But what about the junior lawyers in your chamber? Can they represent you in this case?
Well, the case is not for junior lawyers to handle. If you see what is going on in the realm, so I need to be there, because the one who hired me needs my experience and gravitas. I mean, to come to terms with a case that since Gordgesberg's, time of the Gold Coast, national security matter has never been a subject matter of an open trial. You think it's a small case that we are doing? A dangerous precedent that because of one man, let's cancel the whole of the submarine tactics of national security and put national security on trial. I don't think a junior, will be able to face such an unprecedented, case coming from the Attorney General. So I couldn't cede space to a junior to go and do this job for my client, with all respect.
But legal vacations are part of the architecture of the justice delivery system. And I notice you make the point that legal vacation and the vacation judges must only hear the motions, and as being said today, interlocutory matters. But I notice also that when it's the case of the matter before a judge is a substantive matter that a judge is already hearing, that judge is allowed to hear those cases as well. But in that same case, that judge can also hear interlocutory matters from other judges on vacation. But when a matter is substantive before them, they can hear those cases.
That is the election of the judge. But it should be referable to the convenience of the lawyers. So therefore, if the judge on his own motion believes that a part-heard case in a land matter should continue, but the lawyers have traveled to Singapore, how is he going to secure, their buy-in to continue? Let's get it clear. And the warrant is telling the judge that continue with these two cases. That probably is very consequential for the Attorney General. So that's the selective justice I'm talking about. So if you want a part-heard case heard during vacation, it behoves the judge to get the buy-in of the lawyers, because if the lawyers are not present, how are they going to conduct the case? Because of what the law says, they should go on legal vacation. And let's get it very clear. I mean, this particular one is a special thing for somebody, because probably somebody wants special results.
Explain that, because I've heard you make the point today. It's just for somebody wants special results. What do you mean when you say that?
Well, somebody believes that, at the end of the day, MPP could not jail some individuals, no? The whole of the time of the MPP, they couldn't do 10, cases successfully. And this is our time, and we've not done 2 years. We've secured about maybe 5 or 10 convictions. And therefore, so long as I am in a hurry to get people convicted, I mean, I'll push the lawyers to come and work during the vacation. That's how I see it.
So this, as far as you're concerned, is part of a grand conspiracy to simply railroad your clients, get them fast-tracked convictions for the NDC to prove a point that the oral case, I believe, the oral agenda is moving along as was intended.
You cannot run away from this inference. Because what is the ambulance nature of this trial? What is special about this case? Why do we believe that, for whatever reason somebody is having, we should continue with these cases? And what about the other cases? They don't matter in the realm. Is that not so? Somebody has murdered another person. There's a part-head case. The judge who is doing the part-head trial is resting. So why Boahen's case? So these are some of the matters that we should question the Chief Justice's discretion to give a warrant to a judge that, look, no matter what it is, whether the lawyers are ready or not, let's foist these cases on them, and they should come and continue the trial.
If we take the suggestion of a conspiracy, then that suggests that the Chief Justice is part of the conspiracy in league with the NDC.
You are saying that, but is it not logical to you? What is the point of the matter? What is it that anybody is trying to achieve? Yes, if NDC would want to have convictions, it should go through the rule of law. And nobody should aid anybody to get somebody convicted. They should come to court and, with the greatest of respect, let the system run and then prove beyond reasonable doubt. But you can't find anybody saying that, this is the temperature of the executive. The judiciary should give aid to that so that people suffer, in a manner that even when the lawyers are on vacation, let's hold them because some people are in indecent haste to get some cases cleared off. I can't come to terms with that, I can't come to terms with that.
Earlier in your submission, you made the point that hearing of cases, substantive cases in a vacation court before a vacation judge, is subject to the convenience of the lawyers. And I've seen that articulated in the Ghana Bar Association statement, the letter they wrote to the Chief Justice. But if we are to take that point, though, you're suggesting that the administration of justice and the conduct of a trial is somehow subject to a lawyer's dictate and not that of the judge or the court.
Far from that. I've brought to your attention a very foundational issue, the statutory provision of legal vacation. If they believe that we shouldn't rest, what was the sense of the Courts Act and by extension CI 47? So it is envisaged under the law that the lawyers and the judges should rest. What is the meaning of legal vacation? Is it semantics or is practical? And therefore, when a man wants to rest, and a judge believes that there's a part-head case, a very prominent land in Pram Pram, it's a subject matter of a trial, and it's part-head, he should seek the buy-in of the lawyers. That, are you able to come so we continue with the part-head case? Because we know that the bar and the judiciary, they are Siamese twins. If you separate them, it won't work. Administration of justice can't work. You need lawyers to appear before judges before cases are conducted. But how can you say that you want to run a case like an ambulance at the expense of who? So if the lawyers are arresting, it doesn't matter to you at all because somebody is an indecent haste to secure political convictions or criminal convictions or whatever conviction they are interested in. I believe that justice should not be hurried because of some people's convenience politically. They prove beyond reasonable doubt. Hasn't gotten party colors at all. And one of these days, we will all see that at the end of the day, all those people who want to set aside the force of the law to catch up with them in future.
Mr. Thatcher, please stay with me. Let's explore the points you've made a bit more with your other colleagues. Roxy, he makes a very fundamental point, and I've seen that the MPP has articulated. He asks one simple question. Why is it that the hearing of the substantive case is restricted to these three high-profile political cases, which involves three members of the previous NPP administration?
Thank you very much. Let me say good evening to my big brother. I adore him a lot because he's very deep and erudite. And my brother, the new president of the Lawyers Forum, Young Lawyers Forum, as we used to call it. Yeah. Is this still the case?
Yeah.
Great. So you are welcome. And our viewers. But my senior is wrong. And he knows that he's wrong. Look, I have data in respect of his office. Senior runs a chamber called Zoe, Atta and Co. And he has about 17 lawyers listed as members of his law firm. And you see, let's place these matters in some context. What is the business of the GBA in this matter? The GBA has no business in this matter.
No, but the lawyers who have been affected are members of the association.
No. It's the lawyers. It's not the law firms. GBA is saying that they receive petitions from law firms. Law firms are not part of the Ghana Bar Association.
But the lawyers in the firm are.
Good. GBA didn't sit down. You see, GBA is an association of lawyers. And when we are lawyers, we are a community of reading men. And we deal with legalists. They didn't set the issues like that. They told everybody that they got petitions from law firms, not from lawyers. He's a member of Zoe, Atta and Co. He's not a law firm. He's the one complaining. It's not a law firm that is complaining. So first of all, GB has no business in dealing with this matter because the law firms are not members of the Ghana Bar Association. The Ghana Bar Association is constituted by lawyers licensed by the GLC. The law firms, properly so-called, as we call them, chambers, they're also licensed separately by the GLC. So if you got a petition by some law firms, you ought to have written to them that there's a proper forum convenience for them to direct their petition. But I'll deal with the issues. Atta has 17 lawyers in his law firm. And in my formative years, there were some of the lawyers that when I arrive in court early and I'm able to find my way and handle my motions quickly, I sit and listen to them. It needn't take how long it took because they were such lawyers. They taught us law in practice and we have imbibed and we are here. He knows that the case is presently litigating will fall flat. These matters have always come before the law court. So as far back as 2000, the year 2000, Justice Badu in the matter of Boido and Tai had cause it was even a civil matter. He had cause to say that where a hearing notice is issued and served on a lawyer in the party, and the party gets to court and the lawyer writes to say that he has made vacation arrangements, the court is minded to proceed with the matter. Unless the court is minded to give the party opportunity to produce another lawyer to deal with his interest in the matter, or the lawyer gets back quickly to say that he is prepared to return to court at a more convenient date. And I'll tell you, he knows that during vacations, I made some of my names at the bar from vacation trials. What will my boss do? He knows my boss very well, Teprehudu Chasaibo. He would travel for like a month and maybe and a half. So he will write. Normally he will write to the court that I am not available to handle the trial. But out of courtesy for the court, because a hearing notice has been issued for me to appear during the vacation, I will send my genius. So let them hold my brief for a copy of adjournment. So sometime in September, he will come and then they will agree on a date. Because you see, at the bar, we extend courtesies to the court.
He's explaining why he can't do that.
No, so let me tell you. And I'm also countering that with the number of lawyers he has under his watch. And he's such an excellent lawyer. He's been Jerry Rawlings' lawyer before. So he's such an immaculate lawyer. He knows that when you have genius under you, must give them opportunity to fly. And you use vacation cases sometimes to do that. So some of his junior partners could have gone to court to say that, our managing partner who is in control of this matter has maybe traveled for a couple of reasons. Those reasons will be stated. And therefore, he's pleading that he should be given a couple of weeks to return to take control of the matter. The court in vacation will grant you.
You're certain?
I'm certain because we've done it many, many times. Especially in October, if we pray that you want to return in September to come and deal with the matter, the court will grant it.
So you're saying, although the Chief Justice has said sit,
yes,
the discretion is left to the judge to decide.
It is always negotiation at the bar, between the bar and the bench, always.
So that if you don't appear before the judge, you will know.
Look, we were in this country, 2023. Atufosi was attending court every day. His lawyers at the time pleaded with the court that the everyday trial was most inconvenient. Why? Because they have other cases.
But that wasn't during the vacation.
Good. No. So don't, but they did it also in the vacation. Now, what the court eventually agreed with them is that, okay, instead of the daily trials, we can let you come maybe 3 days in a week so that we can have 2 days in a week to deal with your other clients. The same approach was done in the Jachi case. Jachi was ordered, his lawyers were ordered to appear in court every day. In these circumstances,